Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we are discussing the I-864 and the legally binding nature thereof associated with U.S. marriage visas. So we're talking about the CR1, the IR1, the K3, some of the preference categories associated with those married to lawful permanent residents in the United States. We're talking about all these types of visas in this video, and we're specifically talking about the I-864 and the legally binding nature thereof. For those American citizens watching this video who are trying to decipher some information about how affidavits to support work, and who are currently debating whether or not to seek a K-1 fiancé visa or a U.S. marriage visa, I would urge you to check out another video that was made around the same time that we made this video concerning the I-134 affidavit of support and the legally binding nature thereof. The thing that should be taken away from either of these videos is, notwithstanding the legally binding nature of the affidavit itself, lying or misrepresenting oneself or misrepresenting facts in an immigration adjudication could be punishable with criminal sanctions. It could also be a grounds for finding of legal inadmissibility to the United States pursuant to fraud and misrepresentation. So we're more talking about the legally binding nature of these affidavits, and I'll get into that a little more here in a minute. But quoting directly from Chapter 20.5 from U.S. Citizenship and Immigration Services, uscis.gov, quote directly, Section 213A of the Act and 8 CFR 213A require most family-based and certain employment-based intending immigrants who, on or after December 19, 1997, seek to enter the United States as immigrants or who apply for adjustment of status to establish that they are not inadmissible under Section 212A4 of the Act by having a sponsor sign a legally enforceable affidavit of support on behalf of the affected intending immigrants. So let's be clear. The I-864 is legally binding. What does that mean? That means, for example, let's take it in the context of the wife of an American citizen who's coming over to the United States on an immigrant spousal visa. What that means is the wife who comes in the United States, if she avails herself of means-tested benefits within the United States, it may be possible for the U.S. government to go ahead and seek recompense for the expenses associated with those means-tested benefits from the sponsor who signed the legally binding I-864 affidavit of support. This is also true for those who are joint sponsors of an I-864 affidavit of support, as they might be considered liable, joint and severally liable, for such expenditures as well. So we're talking about benefits given out by the U.S. government may be recompense for such benefits may be sought by the I-864 affidavit of support signer who signed it as a sponsor in association with an immigrant visa case. For specific information regarding the I-864 in the context of the adjustment of status process and how the I-134 interplays with that document, I urge you to check out another video that we put up on this channel specific to that issue.